I have a question. Can I share my screen or my screen for my short presentation of the judge initiative, or I think it has been deactivated. I have a question. Can I share my screen or my screen for my short presentation of the judge initiative, or I think it has been deactivated.
I'll fix that for you, Mehdi, as soon as you have to make a presentation.
Okay.
Yeah, thanks. We have the special rapporteur now. I think, Judge Ntaba, we can start. Justice Edward will join us as we proceed. As Vanja has already said, if you need interpretation, please click at the bottom. There's French interpretation, and we also do have sign language interpretation. We are also live on our YouTube page. So thank you. Over to you, Judge Ntaba.
Thank you so much. Welcome to today. Everybody is looking forward to discussing the doctrine of void of for the sake of vagueness, as well as the issues of seditions, which a lot of our countries continue either to have on the statute book or are things that we're currently grappling with. And we do know that in terms of democracy, the concept of freedom of expression and freedom of speech is one of the fundamental tenets that we need to have in order to ensure that democracy can work and that citizens can voice their concerns, but also put out their opinions out there in the world. So I welcome to everybody. We do have an esteemed panel of persons that are going to talk to us about this particular issue as it relates around across the globe. But more importantly, we also look forward to you discussing it with us, either through questions, through comments, and if the opportunity arises, through you voicing your own voice through the webinar. Now, getting right into it, I'm going to call upon Ms. Vanya Kath from JIFA, which is the Judicial Institute for Africa, to give us her remarks. Thank you. Over to you, Vanya.
Thank you very much, Judge Ntapa. Good afternoon, everybody. My name is Vanya Kath. I'm the director of both the Democratic Governance and Rights Unit, based in the Faculty of Law at the University of Cape Town, and of JIFA, the Judicial Institute for Africa. Through JIFA, we provide university-certified training to judges and others in the judicial ecosystem. We provide short courses, and we launched a postgraduate diploma this year in judicial studies as well. One of the things we try to do is also keep judges and lawyers up to date with current issues in law, and this is why we are here today. We have partnered with our colleagues from SELC and from African and we're hoping that this is the start of a longer engagement through a webinar series where we can really engage with some of the tough questions on the continent around the law and around judicial decision making. Thanks very much.
Thank you, Vanya. Now to set the ball rolling, I'm going to just give you the offense of sedition as it currently relates across the world. Just give me a minute to share my screen. I don't know if everybody can see it. Can everybody see my screen?
Yeah, we can see it.
Okay, all right. I'll start with Arundhati Roy's comments where she says, pity the nation that has to silence its writers for speaking their minds. Pity the nation that needs to jail those who ask for justice, while communal killers, mass murderers, corporate scamsters, looters, rapists, and those who prey on the poorest of the poor roam free. And she is a person who was charged with sedition in 2010. And one of the things that a lot of us will realize, especially us from common law jurisdictions, is that sedition is a colonial relic. And in that, it was used to silence people, especially those who are criticizing, those who are protesting, and those who were just critical of the institutions as they existed then. We do realize they negatively impact freedom of expression and the ability and freedom of speech, and it impacts people's, especially journalists, media, activists, and politicians, to engage in a free exchange of information, but also just debate. Penal codes and sedition laws are often vaguely worded. Being a drafter, I actually do know why, sometimes of the reasons why we actually like being vague in our drafting of the laws, allowing the government to abuse its enforcement to suppress freedom of speech and detain the opposition. And what you would look at most times, freedom of speech, sedition in itself does have a big issue in terms of publication, whether it's uttering with a seditious intention or tendency. And seditious intention is defined as to bring into hatred or contempt, or to excite disaffection against the person of the president, the government as by law established, or the Constitution. To excite any person to attempt to procure the alteration otherwise than by lawful means of any matter in state as by law established. To bring into hatred or contempt, or to excite disaffection against the administration of justice, which is what some of the role that judges and prosecutors do, and to subvert or to promote the subversion of the government or the administration of a district. And it's often subject to abuse. As noted, the definition is vague and very subjective. Disaffection or discontent, which is a very subjective term. And in many instances, the offense extends beyond acts intended to result in violence or an unlawful overthrow of government. And there is no defense of truth like you would have in libel sometimes, or defamation. The defense often also contains presumptions of intention, which is a very hard thing to do, especially when we look at the concept of intention as it comes into criminal cases. And even where the offense allows for the defense of criticism of the state, the chilling effect of on expression is already achieved through the arrest or through the threats that the government would have done during that time. We might say that we are lucky that a number of countries across the world and across Africa have repealed their sedition laws. And I'm glad my country did also in November 2012, when they repealed section 51, 50, and 52 of the Penal Code. But in Africa, Parliament did it in 2001. Liberia did it in 2019. Sierra Leone did it in 2020. And if you look at today, as we're talking through the courts as well, Nigeria did it in 1985, Uganda did it in 2010, Kenya 2017. And as you will know, Justice Edward will be coming through and he's speaking from the ECOWAS court. They did it in 2018. And the East African Court of Justice did it in 2019. The Caribbean through Parliament in Jamaica 2013. And South Asia through the courts in Pakistan in 2023, which is amazing that it was done as recently as this year, and India in 2022. And it is for that particular reason that we are very much looking forward to the panelists that are going to speak to us today. I'm not sure if Justice Edward Asante has joined us, but if he has not yet, I will start today's session with our second panelist, Mr. Clement Baulu, Special Rapporteur of the Rights of Freedom of Peaceful Assembly and Association. He will then be followed by Mr. Mendy Bachelor, who is the Senior Project Officer on Freedom of Expression and Safety of Journalists at UNESCO. And hopefully by that time, Justice Edward Asante of the ECOWAS Court of Justice would have joined us, and he is from Ghana. We are looking forward to your presentations. I will be very strict with time, being a judicial officer. So I will ask that you be very straight to the point and ensure that we get from you so that we have a robust discussion from the participants who are online. So over to you, Mr. Vayo. You're muted.
Thank you very much, moderator. Oh. You have someone.
Proceed.
Okay.
Proceed. Thank you.
Okay, great. Thank you very much, moderator. Let me first thank the organizer of this important webinar, the Center for Human Rights, for the invitation that was extended to me to attend today's discussion. I want also to acknowledge my fellow panelists, and I hear that there will be the Honorable Justice from the ECOWAS Court of Justice, and also from Uganda, if I'm not mistaken. Let me first say that we have witnessed a very worrying trend around the world. As a special rapporteur on the freedom of association and assembly, we have then witnessed these worrying trends around the world, which states intend to instrumentalize, for example, anti-terrorism measures to repress, criminalize, and stigmatize activists, civil society members and organizations, and entire protest movements. And most of the time, this criminalization is based on vague anti-terrorism measures and law that have been used by the states under the pretext of the national security or public safety, and to grant broad power to law enforcement and security agencies to use excessive force to suppress peaceful protests. So when in accordance with the international covenant on civil and political rights, let me say that the counterterrorism legislation should be sufficiently precise to comply with the principle of legality recognized in international human rights law, so as to prevent the possibility that it may be used to target civil society on political, religious, or other unjustified grounds. So along with my UN other colleagues, we have highlighted the danger of over broad definition of terrorism in domestic law that falls short of international treaty obligation. To be prescribed by law, the prohibition must be framed in such a way that the law is adequately accessible so that the individual has a proper indication of how the law limits his or her conduct, and the law is formulated with sufficient precision so that the individual can regulate his or her conduct accordingly. And this was again reminded by the Human Rights Commission in the General Comment 37. The failure to restrict counterterrorism law and implementing measures to the country of conduct, which is truly terrorist in nature, has the potential to restrict and infringe upon the enjoyment of rights and freedom in absolute way, including exercise of the freedom of expression, opinion, and assembly. To minimize the risk of counterterrorism legislation being misused, criminal offenses must be in precise and unambiguous language that narrowly defines the punished offenses. Some of the recent examples that myself and my colleague we have to deal with in this particular area related to the broad definition or broad provision that is used to criminalize activism. One of the examples was Sri Lanka, where recently, along with other of my colleagues, we challenged the law on anti-terrorism law, the anti-terrorism. And I call on the government of Sri Lanka to amend the definition of terrorism and other vague provision in anti-terrorism legislation to ensure that the definition and language employed are in compliance with Sri Lanka international human rights obligation. Another way also that many states are adopting those vague definitions to criminalize defenders under the pretext of terrorism or sedition is also the issue of foreign funding. We have also seen states passing law with vague terms that have been used or abused by authority to criminalize or prosecute civil society actors, particularly human rights defenders and protest organizers, for receiving and using foreign funding to support their pro-democracy activities. Restrictions against foreign donation have been also justified, for example, to prevent undue foreign influence on political parties or protect the integrity of the electoral processes. However, such measure cannot be based on vague and overly broad terms which do not comply with the principle of legality. Another example was the Egypt, when the Egypt amended its criminal code in 2014 to increase penalty for organizations that receive foreign funding with the intent of harming the national interest or public peace. We have also another example of the national security law enacted in Hong Kong in 2020. That also criminalized both Hong Kong and international actors who commit or collude with a foreign country or with external element to endanger state security. One example also that we dealt with, and which is still a concern, is in Algeria. The penal code that was amended also in 2020 to punish with imprisonment of 5 to 7 years anyone who receives funds to carry out or incite to carry out acts likely to undermine the security of the state, the stability, and the normal functioning of its institution, national unity, territory integrity. And as I mentioned, this such vague definition that is used in most of the cases for the political purpose and for the purpose also to leave the possibility of the state and agents to criminalize the work of activism and political party, it should be repealed. And we remind that such definition also have a chilling effects, because if the punishment or if the offense is not precise, then the people or activists are afraid to be able to engage themselves in activism, because they are afraid that the law can be used against them, precisely because the law is not clear enough on what act constitutes a criminal offense. And I want also to highlight again that in this context also we saw a lot of protest movements that was also criminalized based on such vague law. We have also seen many states that passed the such law designed to address security or challenge connected to the terrorism, violent extremism, or organized crime and other national security. And this most of the time is based on the fact that states want to combat national security. So national want to combat concern relating to the organized crime or organized crime. In many cases, some of these laws, what I want to highlight here, are lacking a legitimate aim, or they are broad in sense that the content of the law do not really allow defenders and civil society to understand precisely what they can expect in case of them implementing such activity or engaging in the defense of human rights. For example, we have seen also some of these laws not in the continents. For example, in the context of mass criminalization of peaceful protests, that we have seen also such law like lèse majesty law in Thailand, for example, and lèse majesty and sedition law in Thailand. That was also used by the Thailand authority also to criminalize pro-democracy protests. We have also seen in India authority that increase the use of such vague law and sometimes also the vague definition colonial area sedition and anti-terrorism law to convict peaceful protests, including in the context of large-scale farming. If you remember, well, 2 years ago, farmers' protest. Another issue that I would like also to highlight here is also the issue of online, the use of such vague definition to criminalize any online activity. We are also seeing this emerging on the continents, and I noted this in my reports in 2019, that is important for the state to protect online activity, in particular when it comes to the online activism and the exercise of the right to peaceful assembly and association. We have also seen in Niger, where the overbroad definition of disinformation laws not only criminalize journalists, but also anyone that publish or anyone that share information that can be just this information can be also tagged as being fake news in particular. So we are seeing also this type of law emerging, which is entitled fake news laws, but their contents, and if you look at their contents, you will also see that one of the main objectives is also to prevent any criticism or any critical position against government and against leaders that are in power. So it is important also to highlight here that little by little we are also seeing those criminalization emerging on online space, which means today that any content even published just online, which the person is not the author of this content, or just that the person you take this content from a newspaper, the person will be also criminalized because of the vague definition of fake news or fake news, or what usually people call disinformation. Let me also maybe mention here that in most of the cases that I just mentioned, I have again repeatedly called states to repeal law and regulatory measure, imposing restriction contrary to the international human rights standard, including measures that use overly broad and vague definition to limit civil society organization. Because for me, it's very clear that states need in legislation, in legislating in particular area, in order to ensure that there is a legitimate aim, there is a clarity on what the legislation is about, the definition of offenses that should be contained in this law need to be precise to ensure that anyone can comply his conduct. I want also to say here also that civil society and protest movement should be regarded and respected as partners in order to effectively prevent and tackle violent extremism and to design human rights compliance and effective anti-terrorism law. States need also to ensure that in adopting such measure to combat terrorism or extremism or any other violent conduct, states need also to ensure that civil society is consulted and is also seen as a main partner in fighting against such conducts. I would like also to end to congratulate and encourage the legal practitioner attending these events to challenge criminal law in your respective countries that are vague and contrary to the principle of certainty mandated by international human rights law. In most of the cases, we know that such vague definition is purposely done in order to encompass or to give broad power to law enforcement to punish, to criminalize, or to arrest and detain arbitrary human rights defenders and civil society. And such definition, such vague definition, in most of the cases, there are those definitions that can also tarnish the image of the democracy, because any law enforcement or any authority can use such law And by using such law to arrest defenders, this can also impact the image of democracy, but also intend to show that the country is moving through the authoritarianism, because law is not precise enough, and also the authorities do not have any limit to use such law to punish people. So let me end there, and then I will come back and then to make, if any of these points are not clear, to give more information. Thank you.
Thank you so much. And I must appreciate the role that you play, because I think the reports that you do, the visits that you do, actually do help and shine a light on the human rights violations that are happening, especially in relation to these laws as they continue to remain on our statute book. I will, at this point, call upon Justice Edward from Ghana, who is the president of the ECOWAS Court of Justice, to give us his viewpoints as to how he believes the judiciary can assist in eradicating these human rights violations, but more so promoting and protecting the rule of law, which ultimately most of our constitutions are saying, have legislated for, and are things that we should be doing. Justice Asante, the floor is yours.
Thank you very much. Sorry for being late. Actually, we had a technical problem here, and therefore we had to delay a little bit in joining the webinar. However, we've been able to join, and I thank you all. I greet my colleagues here.
We shall not fine you, although we saw it as a court.
Come again?
We shall not fine you.
Thank you very much. Yes, I will just give an overview of the doctrine of void for vagueness as given by the earlier speaker here, which basically is a doctrine of constitutional law that determines the constitutionality of laws that are too vague to be understood and enforced. We all know that governments these days use those kinds of laws to whittle down on, or to clamp down on opposition, on people, public-spirited people who try to speak the truth and criticize their activities. And unfortunately for them, the judiciary is there to save the situation. In most cases, the judiciary try to measure the activities of these governments against even the internal constitutions of the countries themselves. In the US, way back in 1926, in the case of Connolly and General Construction, they clearly defined such laws and said they were anti the due process, and therefore such laws would be forbidden. And in that case, they said that the criminal statute that either forbids or requires the doing of an act in terms so vague that men of common intelligence must guess its meaning and differ as to its application violates the due process of law. Clearly stated here. And we all know that due process of law has so many strands. Using legislation to try to bog them down is a bit serious in very good democratic societies and must not be countenanced. Generally, they deal with anti-free speech laws, on sedition, criminal defamation, and publication of false news. These are the areas that the laws are very repressive. And sedition has been defined in the Black Laws Dictionary, the 9th edition, as the speaking or writing of words calculated to excite disaffection against the Constitution as by law established. So to procure the alteration of it by other than lawful means, or to incite any person to commit a crime to the disturbance of the public peace, or to raise discontent or disaffection, or to promote ill feeling between classes of the community. This is a very broad definition which governments actually use. And this law, actually, when you define it, will get almost everyone publishing something within the net. And that's a very dangerous thing to be countenanced in democratic dispensations within our community. Criminal defamation laws are also said to be very widely defined within the local laws. Laws prohibiting false, they call them false news, but sometimes they are not false news. They are news that they think will cause panic and fear within the society. But then they are news that are very good for the people to know the kind of policies the various governments are putting in place. And yet they try to define these laws so broadly as to get them in the net, said that people will be very afraid to publish them and to let people know what is happening. The common thread that runs through these anti-free speeches is that they are usually drafted in very wide and ill-defined or vague terms. Many governments, including African governments, employ these anti-free speech laws to stifle freedom of expression by labeling genuine criticisms of government officials or their policies as seditious, as criminally defamatory, or as false news. And these are very dangerous things that we must try to avoid in our dispensation. But then at the international scene, with these international and regional courts, they do not directly have the power to either legislate or to even criticize or amend these internal laws of the member states who are members to the various international regional courts. However, there's been a fashioned out system by them that they all use. For instance, the ECOWAS court, all the 15 member states luckily are signatories to the African Charter on Human and People's Rights, to the ICCPR, and to various international human rights legislation. And using the rule on Pacta Sunt Servanda, the court has able to fashion out certain policies, said that all the countries are supposed to make sure they domesticate the various rules in those legislation within their local laws and apply them. And therefore, if an issue comes regarding the extent of definition or vagueness or voidness of a local legislation and it comes before the ECOWAS court will use the international standards as set out in the international treaty signed by this country and measure it against the law, particular law, mostly criminal laws trying to outlaw free speech or trying to convict people for sedition or for criminal defamation, and use it as a measure to see if the law is good or not. So this is the principle that limitations on human rights, particularly criminal sanctions, must not only be provided in the law or serve legitimate purposes, but they must also be narrowly tailored and be the least restrictive means of achieving those legitimate aims in a democratic society. That is the tenet that the ECOWAS court, for instance, and I know other regional courts use to measure the extent of vagueness or voidness of a local legislation, and therefore try to use it to measure it and then do recommendations. Basically, you cannot on your own amend or repeal those laws, but then you make recommendations to the governments and say that those laws must be repealed or amended within their jurisdiction. In the ECOWAS court, there's a particular case called the Federation of African Journalists. There's the Gambia. And in 2018, the court gave a decision in respect of that case. The applicants were all journalists who were practicing in the Gambia, 3 of them. And the Federation of African Journalists is an NGO that joined them. So the 4 applicants applied to the ECOWAS court to see to the regularity and the genuineness and whether those laws, the criminal law in the Gambia, was very good or bad. In a way, when they came, it was clear that all 3 of them were journalists. They had been arrested and charged for various crimes, including sedition, for publication of false information, and for criminal defamation. So when they appeared before the court looked at the entire provisions of the criminal code of the Gambia, particularly section 52, which dealt with sedition. In this case, I am told to dwell more on sedition. Unfortunately, it is the oldest of all these criminal offenses in a way, but then there are just few cases in the ECOWAS court. that I'll deal with. So section 52 is the offense creating section, and then 51 defines what sedition is. And it said it's the intent defines the sedition. Intent broadly to include any action that is likely to bring into hatred or contempt, or to excite disaffection against the person of the president or the government of the Gambia. Bring into hatred or contempt, or to excite disaffection against the administration of justice in the Gambia, or raise discontent or disaffection among the inhabitants of the Gambia. This definition obviously will not stand. With this broad definition, any person who publishes anything, whether you are the author or you are only an agent, will be caught in the web of that law. Then also they came with the law of criminal defamation that was also broadly defined. Then that of false news publication also broadly defined. And so when the court looked at it, however, the respondent, that's the country, the Gambia, said that it was in tandem with its customs and its special environment in which it was working, and therefore they saw nothing wrong with the laws and that they should stand. But the applicants, however, clearly compared the tenets of the law with Article 9.2 of the African Charter on free speech and all that, and then 19.2 of the ICCPR. And clearly when the court looked at them, and Gambia is a signatory to those two laws, clearly the ECOWAS court found that those laws were, they had a chilling effect which occur when the wide or vague speech restricting provisions force journalists to do self-censorship. And that was clear because they had to do self-censorship for fear of being arrested and detained and brutalized in a way as was pertaining within the country. And therefore, the court said these laws clearly were against their own international obligations, and that those two laws which they had signed. And so advised, and they recommended actually that Gambia must repeal those laws or amend them to suit the international obligations that they had under those two laws. The Supreme Court of that country recently, a case was brought by the press union and others against the Attorney General of Gambia in the same 2018. The Supreme Court reviewed the entire law and looked at the decision of the ECOWAS Court of Justice, recommending repeals or amendments to their criminal code. And indeed, they, in a way, agreed in part with the ECOWAS Court of Justice's judgment by saying that the publications against ministers and that must go, that those were unlawful, but then they retained publications against the person of the president and his government. So at least in a way, there was a leave, the court had made progress, a little progress. They had, in a way, considered that part of their law was not good in terms, though we expected more, because the government, the president and officials were all the same people. So if a publication is made and against an official, the government may say it's government, and therefore virtually it came back to the same thing. But that was what happened in that case. Then also there's this case in Nigeria, which also came to the ECOWAS Court of the local court. There was this Cyber Crimes Act 2015, which criminalized speech or publications knowingly or intentionally communicated via computer systems that were grossly offensive, indecent, pornographic. So many words were used, or so many phrases were used in trying to criminalize the offense. And the punishment was terrible, between 700,000 naira and 25 million naira, or a person could go in for 7 years or to both. That was a bit dangerous. So they came to the ECOWAS Court of Justice for reprieve. The court looked at the international standards on freedom of expression and all that as against that law. And clearly the court agreed that most of the tenets in that law, talking about indecent, grossly offensive, needless anxiety, very subjective. The court declared that most of those things were subjective. However, Unfortunately, the court did not recommend any amendment or repeal, and said that rather the discretion of the prosecutors or the judges will be used in trying to give the good definition. However, looking back now, we think that there was an error in this decision, because clearly the courts have found that it was subjective, and any law that gives itself to subjective interpretation is not good law, because there should be certainty. Yes.
Can I give you a minute to finish up?
Very well. There should be certainty in all these laws. And so, having said that, I think it was a very bad one. Then in Ghana, there's this case of, it was a Chieftaincy Act that gave the chiefs the right to summon anybody before them for certain rights to be performed. And somebody went to the Supreme Court. Supreme Court looked at it and said, it's quite going to whittle down on people's movements. So if you are not even a subject of that chief and he calls you, you've committed an offense. You cannot criminalize a chief merely calling anybody to his palace, especially if the person is also busy somewhere and doesn't come. It's a criminal offense. So the Supreme Court said, outlawed it completely. And in the year 2002, we all know that Ghana also struck down and repealed totally the criminal sedition, criminal defamation law of Ghana. And therefore now in Ghana, there's no criminal defamation under the criminal code. You could go civil. If you think you've been defamed, you sue somebody, and then you have your damages through a civil procedure. Generally, I think the governments, the regional courts actually are trying to do their best to review these laws in terms of laws that have been signed onto, especially the international standards, by these states, so that we could get the best out of them for the citizens. Otherwise, this dictatorship and loosely defined legislation will obviously get people to freeze and therefore not be able to air out the bad things about policy, about governance, and about all those things. So unfortunately, I sent my writer, so I think you have it and you may distribute it to viewers. Thank you very much.
Thank you so much. And it is wonderful to hear that the ECOWAS Court of Justice is looking into these issues and actually making positions and delivering justice that says, look, these laws that are in existence in our various countries do not meet the standards of constitutionality. And not only that, they are very anti-human rights, and as such should be struck from the statute book. I will go to our last speaker, but before I go to our last speaker, I would like to extend apologies from Justice Lillian of Uganda, who was unable to make it due to exigencies of service. So as such, she's been unable to make it to today's panel. The last speaker on today's panel is Mr. Bechala, and he will be taking us through his work as a person who is working on the project on freedom of expression. So Mr. Bechala, the floor is yours. Thank you.
Thank you a lot, Judge Naba, so for this introduction, and thanks for the organizer to organize this webinar. So first of all, I mean, my name is Mehdi Benchela. I'm a senior project officer at UNESCO, and I coordinate a team working on rule of law, policy, and freedom of expression. And in this framework, we work with judicial system globally on the issue of freedom of expression and the link with rule of law. We have this judge initiative that started in 2013, aiming at raising awareness of judge and judicial actors, prosecutor, lawyers, on the importance of freedom of expression and the international standards protecting freedom of expression, and also the regional jurisprudence and sub-regional jurisprudence, such as exposed by ECOWAS Court of Justice, but also East African Court of Justice. We also work with African Court on Human and People's Rights in Africa, but also with the Inter-American Court on human rights. So, first of all, when I think it might be interesting to recall a little bit the importance of freedom of expression. It's for society. It's fundamental rights that is enshrined in the Universal Declaration on Human Rights and in Article 19 also of the International Covenant on Civil and Political Rights. And it's really a key and essential human rights, the right to seek and to receive and impart information and IDs, regardless of frontier. And when we work with judicial actors, we really highlight the importance of this right for human development. Basically, it's very difficult to talk about development, about technological, about anything without this right. Also, it's a right in itself, the right to seek, receive, and impart information, but it's also a right which is enabling other human rights, and that I think is extremely important to highlight. It's not possible to talk about freedom of assembly, freedom of political participation, right to vote without freedom of expression. So if you, and this is one of the reasons when you have an authoritarian regime or a coup or something like this happening in a country, usually the people wanting to control the society will target the judicial system, and they will target the media and journalists, because these are two extremely important elements for a democratic society. Unfortunately, in the last 5 years, according to a UNESCO World Trend report, these rights for 85% of the population in the world, this right of freedom of expression, they say that they express that they experience a decrease on their right to freedom of expression. So really a very worrisome trend that this fundamental right is really under attack. And in this right of freedom of expression, journalists play a key role, because they are really the people who are looking for information, who are making investigation. They are really professional. They are not always, sometimes bloggers and everything can also do journalism. But they are specifically attacked. They're attacked by people who want that they can keep doing trafficking and corruption and things like this. So there is really a huge amount of attacks against journalists around the world. In 2022, UNESCO recorded an increase of 50% of attacks against journalists, of killing of journalists. And in the world, the statistic around the impunity for crimes against journalists are extremely high. It's almost 9 out of 10 killing of journalists is never solved, is not resolved judicially. So this sends a message that killing a journalist is really something that is trivial and that doesn't incur much consequence most of the time. And of course, judicial system and law enforcement have a key role in there to protect journalists, to find the perpetrator of attacks and killings against journalists. Because when people killing journalists, they are, of course, taking the life of a person, but they also deprive the society of key information. And that's the aim. That's why they kill journalists or they attack journalists. Unfortunately, we also noticed that the judicial system have been used to silence freedom of expression in some cases. UNESCO has published recently a report of the misuse of judicial systems to attack freedom of expression. And in this report, we can see that still 160 countries around the world criminalize freedom of expression, which is 80% of states. So it's a really huge number. So, and the campaign of civil society, of different actors to decriminalize freedom of expression has lost some of its steam in the last years. And it's very important because United Nations Special Rapporteur on Freedom of Expression and really highlight that freedom of expression, when there are some abuse, and that happens, they shouldn't be met by criminal sanction and threat of prison. They are the Special Rapporteur really advocate for a civil penalty against abuse of freedom of expression that happens, because this is not an absolute right. We make it very clear, according to international standards, This is a right that can be limited, and in some cases, such as described in Article 20 of the ICCPR, of national, racial or religious hatred that incites hostility, discrimination, and violence, or propaganda for war in other case, they should be, of course, limited, and they should be prohibited by law. So judicial system, they have a key role in balancing all this and find when and what are the criteria when you can limit freedom of expression. That should remain the exception. But so there is the three-part test, which is enshrined in Article 19 of the ICCPR. So this limitation of freedom of expression, they should be legal, they should be legitimate, and they should be necessary and proportional. And UNESCO has developed different tools for judicial actors to better understand these three-part tests, which is key because this is really, in particular, the issue of proportionality of the limitation is extremely important in order not to curtail these fundamental rights. However, it's not only the fact that it's not only, in some cases, not criminalized in some states, but we have noticed a trend of using the judicial system to basically curtail freedom of expression in the so-called SLAP and forum shopping. So SLAP, strategic litigation against public participation. It's really actors, powerful actors, are basically using the judicial system to silence journalists. In some cases, they know they are not going to win, but this is not the aim. The aim is to exhaust financially the media, the journalists, by using the judicial system and by making appeal and et cetera, et cetera. So, and it works because in many cases, journalists and media don't have always the resource to address this misuse of the judicial system, and they are spending a huge amount of money and energy and time fighting this dubious, bogus attacks case against them, and they cannot keep working and do their work of researching information and for the public. So that's really a very worrisome trend, and we think it's extremely important. At the end of the report, there is a series of recommendations that the judicial actors are more aware that they can be used against this freedom of expression. Because this is also interesting because we can go probably maybe more in details in the discussion about that. I don't want to take all about talk about that, but it's important to establish criteria, and so that's really one of the things which is very important. So I think I may not keep too much talking about that. So I can also explain the work of UNESCO in this regards, really in terms of raising awareness of judicial actors. So this judge initiatives so far has allowed us to engage with over 500 judicial actors around the world, and it's around the strategy is around is structured around first the development of resources. So UNESCO developed toolkits for judicial actors on freedom of expression that my colleague Virginia Antonelli is sharing in the chat. It's available in all UN languages, so English, French, Spanish, etc., and Portuguese, and it is also so it really details what are the international standards of freedom of expression, really for what are the legitimate limits, but also the issue of safety of journalists and the fight against impunity. There is a chapter on access to information because judges have a key role in this of access to public information, which is extremely important for accountability of public institutions. And also the issue of internet, which has a lot of different components. We also developed a toolkit specifically on the international standards on freedom of expression access to information, safety of journalists, press freedom, etc., focus more on Africa. So in this toolkit, we go more in details about the jurisprudence of African Court on Human People's Rights, the jurisprudence of ECOWAS Court of Justice that Justice Asante spoke about some decision, and also the East African Court of Justice. So this goes a little bit more into in depth on the continent legal framework on this issue. But we also develop issue briefs such as the one on misuse of judicial system, again, to attack freedom of expression, but also guidelines specifically for prosecutors on crimes against journalists, which are also available in different languages, and also a guide for lawyers on how to present case of amicus curiae on the issue of freedom of expression, and also guidelines on the privacy and freedom of expression, how to balance these two rights. So I have 2 minutes. I will try to summarize. So resources in terms of also videos to explain the three-part test or the Rabat plan of action, which I won't go into detail now, but my colleague can share that in the chat, which very summarizes these very important key tools for judicial actors. Finally, we also have online course, and now we actually do have an open, massive online course which is available that UNESCO is organizing with Oxford University, and I encourage you, one which are interested, to apply for this. It's for 5 weeks. It's just started 1 week ago, and it's issue a certificate from Oxford and UNESCO on completion, and really all these key concepts are being developed in this course. Finally, I will end on this. It's really the key importance of the partnership. All this is possible because of partnership. So UNESCO signed MOUs with the different courts in Africa and in Latin America to really strengthen our cooperation and to train more judicial actors together. And usually when we do a training, we have one judge, for example, Justice Asante comes and present when it's in ECOWAS court, ECOWAS community country, he presents the jurisprudence of ECOWAS when we do it in South Africa. So we really try to work together, and it's absolutely key to the success of the initiative. I will end there, and thanks a lot.
Thank you so much, Mr. Batchelor. I would say I have taken the course on freedom of expression and safety of journalists. So I would recommend that people who are wanting to broaden their knowledge or just recapture what they've lost in terms of time, in terms of that knowledge, to do take that particular 5-week course if they could. I'm thankful to all my panelists, but I think let us go to the participants to hear their views, get their questions. But while we're getting while you're asking questions, if I may ask, please raise your hand so that your mic can be unmuted and you can ask those particular questions. But what I find interesting about the laws that have been vague and have been used to either go against people who are speaking out freedom of expression is that they do take a lot of time to get away from the statute books. I'm looking at our own experience as Malawi. Last time a judge spoke about it was in 2010. And it's interesting that Justice Chikopa, in a case against politicians, he said this, and yes, perhaps it is time we decided whether in their present form, our sedition laws remain valid in the current constitutional dispensation, or whether we still need them. We think not in either instance. And he said this in 2010. And only in 2022, 12 years down the line, did we change these particular laws, which means in the last 12 years, we've still been using them. So it is a major problem, whether through a judicial decision, that they do not still get off the statute books in the time that they need to. So if I may ask anyone who has a question, but there is one particular question that has been raised by Mr. Bunu to both ECOWAS and UNESCO. Let me just get to it. It says, what is ECOWAS and UNESCO doing in enforcing the law to member states? So I'll leave that to the two of you to consider as we wait on the other questions. I am not seeing a show of hands. Okay. I have Kadala with a show of hands. Let me see who else. I saw somebody else. Okay.
Thank you, Chair.
Yes. Proceed with the question.
Thank you, Chair. And let me thank the presenters for a very informative presentation. Mine is not really a question, but perhaps a comment. And my comment is related to the fact that listening to all the presenters, there is no doubt that we do have legal framework, international legal framework at the regional level and also at the national level on freedom of expression, freedom of association and assembly. So my question that through this comment will be: is there something that we're not really doing correctly, in the sense that, for example, to ensure the implementation of those legal framework? I think perhaps it is time that we look at the enforcement mechanism to ensure that member states who have signed international treaties respect or comply with the international treaty that they have signed. So this goes, or look at the enforcement mechanism under those treaties. It seemed to be weak because the framework, the legal framework are there, and they are very clear. And we still, enacting even some general comment and many other, guidelines just for the implementation of freedom of association and expression. And this is perhaps time also that we look at the role of the judiciary. What is the role of the judiciary, not only at the national level, but also at the international level? How many cases are before this, for example, the African Court of Justice on freedom of association and expression? How many cases are there at the national level looking at the state violation of this important freedom? So it is time, perhaps, Chair, that is my comment. It is time that we look at the role of the judiciary. And the question is, how many cases are there so far before national and international institutions? Thank you, Chair.
Thank you so much, Mr. Kandala. I know you didn't introduce yourself, so I'm not sure where you're from. May I ask Jairaman, who also had a hand up, to speak?
Thank you, Your Honor. My name is Maitri Jayaraman. I'm with the International Legal Foundation. We have lawyers around the world, and we provide legal aid for people from marginalized communities who have been arrested for committing crimes. I appreciated the comments from all of the panelists. I have two very specific and sort of just practitioner questions. I would direct them to Justice Asante, but I would be happy to hear answers from anybody. My first question is, I appreciate that today's presentation was using the Vagueness Doctrine specific to sedition laws and rights to assembly and expression. But of course, we can use the Vagueness Doctrine in challenging other laws. So my first question is there any modification or change in the application of this legal doctrine that you would recommend when using this Vagueness Doctrine to challenge other non-sedition type laws? And my second sort of practitioner question, Justice Asante, is what do you find that practitioners do wrong in terms of when we are in court arguing this in regional courts, in national courts, local courts? What is the biggest thing you find legal aid or other attorneys doing wrong in our arguments or missing in our arguments? Thank you.
Thank you so much for those two questions. I'm going to ask my panelists to respond to them. Can I please ask Justice Asante to start? Then I'll go to Mr. Bechala and I'll go to Mr. Voyo if he's still online, because I'm not seeing him at the moment. Oh, he's still here. Yes.
Thank you. Thank you very much. Yes, the last question, talking about modification to the vagueness or any alternative to the vagueness issue. It's a bit difficult. Compared to the national courts, where they have specific procedures to follow, the international courts are, as you all know, courts that complement the activities of the national courts. So ECOWAS court, being a regional court, has its own procedures though, but they don't have oversight responsibility or over the laws within the member states. And therefore, it will be very difficult for you to say you are fashioning out procedures and all that. That is why we piggyback on this issue of this doctrine, which is being used against criminal laws generally, and trying to pin them down to their international obligations and international laws. But I think that is a very fair and good one. Only issue is enforcement, which has also been asked. On the enforcement, we all know that international or regional courts have difficulty in enforcing judgments. The only issue is that it is basically based on self-will of the member states. That's the very sad part of it. And we try, on our part, to get this naming and shaming of countries during annual or biannual summits. We're trying to get there. ECOWAS court is trying to get into the summit of heads of states and governments, so that the president of the court will at all times make a review of the court's activities, present to them a report containing judgments that have been delivered, name the member states, those who have complied and those who have not complied. And I think in a way, that is a way of getting it done. But they themselves, actually, the laws are to the effect that they have to enforce the judgment themselves, which is so sad, because how can the Attorney General who came to court against whom judgment has been given go into the country and do the enforcement? It's only by self-will. So it's a bit dicey and difficult for us. Talking about where lawyers go wrong. Well, basically, the lawyers do their work, except that one thing is doing the wrong arguments and sometimes even citing the wrong laws. Sometimes, of course, the ECOWAS court being a human rights court, even when the lawyers cite the wrong law, we use this doctrine of substantial justice, and therefore we proceed to make sure that the substance of the matter is gone into and not the technicalities. Though opponents of those who have come to court may want to use the technicalities to have the matters dismissed, but being a human rights court, we try to use the substantial justice text, and then we proceed with the case. So generally, except that I also advise that lawyers must also be a bit up and doing and prepare their documentation, their pleadings very well to the highest standards, so that they can win their cases, especially on freedom of expression and human rights violation cases. Because sometimes the court's hands are tied. If the evidence is not too good, the court in those cases may have no option but to dismiss your case. Thank you very much. I hope it satisfies the questions.
Thank you. Can I have a response from Mr. Bechala? Is our enforcement weak?
Yeah, so no, but the issue of enforcement, of course, is very important, and it's a big challenge. We all know that. And it needs a lot of advocacy. I think the role of civil society in that case is crucial, because because judge, that's what often the judge said, they are adjudicating cases, but they are not the specialist of advocacy. This is so that's why also it's important to collaborate with the UN agency or civil society, to everybody in its own capacity and role. But really for our part, it's really about encouragement of member states to abide by international treaty that they ratify willingly. So they establish these courts, and their decisions are binding for the regional courts. So these are very powerful decisions. And we can see in some cases an enforcement and some other resistance. We also should remember that even for the oldest court, regional court, which is the European Court on Human Rights, this has been a long process. And today the decisions of the European Court are more enforced than they used to be 20 years ago. So we can also have a little bit of a perspective in this, that there is a trend, but it takes time for sure. But really more advocacy with member states for them to really respect this decision. Often this decision have financial consequence because they award reparation to, and this is a key point also, and member states are very difficult for them to pay these victims of violation of their rights when the regional court adjudicate compensation. This is really also an important point that is to remember. Other things is also for the enforcement is also the more how to say, awareness from the Supreme Court at national level, because national courts, they can also use more the regional decision to enforce, and that's something that is important, that the judge at national level are more aware of the decision from the regional court, human rights court, and that they use it, that they quote it. So it's a little bit more easy in the common law. But it's not enough, and we can see in some cases decriminalization. The Konate case has been quoted. You can see, so it is there in some Supreme Courts at national level use this regional decision to strengthen their case, to decriminalize, for example, in some case, freedom of expression, but defamation. But it really it should be more. So that's also. It depends on different countries and everything, but the judge at national level could be a little bit more daring in that sense. And finally, I think also the lawyers, they can also strengthen their proposition. I mean, basically their case, and that's why also we developed this amicus curiae on freedom of expression case in order to give more tools for the lawyer to present stronger cases, and that will arrive at the regional court with a little bit more structure. So that's one of the things that we have. It was actually a request, and so I will end up here. Thanks.
Thank you. And Savoy, any response?
Yeah,
if I take the next set.
Yeah, thank you very much. I think my colleague already elaborates on most of the issues. I think it's still for me important also in trying also to kind of change, because for me the one thing that is important, and which some of special rapporteurs and also mechanism are doing, is also how to bring states to really amend such law to bring them in compliance with the international standard. And I would also say that lawyers, including civil society, should be also using a lot on some of those products and communication that we put there. In most of those cases, we have been engaging with states. We have been also sometimes also engaged in some of the amicus, the regional and national level, which are important advocacy tools in bringing changes. And I think we should be using them more and trying to kind of ensure that those laws can be revised and can be in line with the international standard. And also, I think there is also need in terms of national judges also knowing about the international laws and international obligation of the state, because it's happened that you can see most of them really focusing on on national law, but with really limited knowledge about the international standard and the state's obligation, which is important also to focus on and to make sure that judges that will be taking decision are aware and knows about some of the challenging that this sedition laws poses. So this is what I can add, and most of our work also is focused on that. We do quite a lot of this work engaging with state, but also local actors, and trying to in ensuring the amendment of such laws.
No, thank you. Very interesting point of view. I think you are right. The partnership is important, especially when you're looking at advocacy and looking at strategic litigation. The use of international law itself in national laws, I think, becomes critical, especially when it comes to human rights violations.
Yeah.
How much has the state gone and said they are going to be held accountable internationally, but also locally by their international obligations? I'm going to take the next set of questions. They're coming from first. I'm going to ask Ruth Nkutumula, who's going to give her points, then seconded by Maxwell Nkambule, and lastly, again, Mr. Kandala raised that he wants to raise a final question. So may I take those questions in that order? Thank you.
Thank you very much. Ruthie from Disabled Women in Africa in Malawi. I'm glad about the presentations that we have had today, and I just wanted to seek clarification on almost 3 key areas. So, for instance, I wanted to understand what measures are being taken within Africa legal systems to address cases where persons with disabilities are unable to provide informed consent due to their condition. Secondly, I wanted to understand if there are any other legal resources or support services that are available for individuals with disabilities who have experienced sedition related offenses in Africa, but also just to understand what are the examples of some of the cases that can be taken to the ECOWAS courts. And finally, the issue of accessibility within the national courts. I think as our organization, we conducted some research a few years back, and we discovered that most of the Malawi courts are not accessible to people with disabilities, whether they are physical infrastructure, but also even issues of information, legal representation, and all that. And most the accessibility is within the courts, but also even where they need to access the information. So how are we working around on that? Because the such barriers will prevent one to even access justice, and if issues of consideration of mobility issues for people with disabilities, where they have to go and follow up on a case several times. Sometimes it just depends on if the judge has some passion to say, okay, let me rule out on this case. But if not, they'll just do the way it is done. How do we really ensure that the access to justice is for all, and people with disabilities are recognized with their needs for reasonable accommodation? Thank you.
Thank you, Ruth. Can I have Maxwell? Maxwell?
Hello. Thank you, Judge Taba. Can everybody hear me?
Yes, we can hear you now. Thank you.
Thank you so much. Afternoon, everyone, and to the honorable judges. Mine goes to, and hello, Clement. Mine goes to all the honorable judges here, and including yourself. Judge number 2, ask, I'm from another jurisdiction. I'm from Swaziland. And I think these sedition laws are still a problem with us in Swaziland. And if anything goes according to plan, the matter will be coming to court next week in an appeal. But mine is strictly to ask, as a question of conscience, and what actually gets to goes down in the judges' forums. To the judges in some forums, which are, or in some jurisdictions, which are as troubled as that of Swaziland, and when they go to those forums, do they get to be assisted? And is there a room for matters which are more critical and which are actually affecting the rights of every Swazi, and I mean the rights of every citizen in any country? Is there an element of discussions around those matters to sort of assist and uplift each other in that respect? That would be all.
Thank you. And finally, Mr. Kandala, can I have your final comments, very short, because I do need to make sure that I have two other speakers who need to speak.
Madam Chair, this was a legacy end, but if you want me to ask a question,
no, that's fine. All right, I'm going to just,
yeah.
I know you have a comment, but maybe just put it in the comment section so that everybody can appreciate it. Thank you. All right, can I have my two panelists who are remaining, because we've had to lose the special rapporteur. He has another engagement. May I start with you, Mr. Bechala?
No, I can just relate it to the question about person with disability. UNESCO has produced a certain number of resources about the challenges of the disability, access to information and knowledge for a person with disabilities. So we can share. I can share with on the chat the reference of this resources. For more information that might be of some use.
All right, thank you so much. Justice Asante, just a quick one.
Thank you very much. Yes, on persons with disability, I must say that as part of the court's disability activities, the court does sensitization in member states annually. We go to about 3 member states per year to do sensitization, to meet with indigent citizens, various interest groups, civil society organizations, lawyers, and all that, and let them know what the court does and what the court is capable of doing for them. Therefore, sometimes we even meet groups with people like people with disabilities, and we tell them about their rights and all that. Talking about this right issue, the ECOWAS Court of Justice is mainly a human rights court. Actually, it was started as an interstate court to deal with matters between the states themselves. But now about 90% of the cases are human rights violation cases within the region, the sub-region of 15 member states. So those are the types of cases we deal with. And talking about disability again, the court used to sit in member states a few times, depending on the situation. For instance, there's a case in Sierra Leone. We intended sitting there, but the COVID scattered our idea because it was about Ebola, and there were so many victims, so many people who had wanted to testify. And therefore, looking at the situation there was no way they were going to fly them to Abuja. And therefore, there was an intentional application to move there, but the COVID scattered the activities and the court couldn't go there. Luckily, again, the court now does Zoom sitting, and therefore, whether indigent applicants or people living with disabilities or any other person do not now travel to Abuja, the base of the court, to have their matters heard. You, as a witness, you go to your lawyer's office, you see him there clearly, you are sworn in, and you testify for the court to see. You see us and all that. So basically, these are things that the court has done to improve upon its visibility and on trying to support indigent applicants and people with disabilities so that they also have some fair share of the case. So that is what I'll say for now in respect of these questions. Thank you.
Thank you. And I think going to Mr. Kambule's question, whether judges forums across Africa or across the world actually do assist in either encouraging judges from other jurisdictions. I think they do. They do act like networks. They act like resource hubs, because I do belong to a number of these judges forum, and I have seen that they do assist in helping you come up with, should I say decisions, by the mere fact that they're able to offer you resources for the decisions that you have. But they also act as an encouraging space, because I do realize that when you sit as judges, these roles, these positions are very high risk institutions, and also institutions that can take you away from society. So I would say that definitely that those forums do help. And it is the hope that once we are in these forums and we get this encouragement and we get these resources, then we can do our work effectively when we're back in our jurisdictions. When these kind of cases come along, I can personally say that they have been able to assist me in a number of my decisions in terms of resources, but also encouragement to see what other judges have done in the face of adversity in their jurisdictions, to be, as they say, very brave to take on the decisions that need to be taken on a lot of human rights violations. So I would say definitely yes, those spaces help. And those spaces are also used as advocacy and lobbying spaces for various issues, and those are the spaces that you can also train the judges and magistrates in all these issues, because they are spaces that are for them and specific to them and safe. So as much as possible, I would encourage you to use those spaces. With that regard, I'm going to be asking our two last speakers, our two panelists, to make their final words before we go to Lloyd Kuvea and Maria Badeva Bright to give their closing remarks. So may I ask Justice Asante, what are your final words before we head to close this beautiful webinar that we've had today?
Thank you very much. My final words are very few, and they are an encouragement to particularly Africa, that all is not lost, and that the judiciary is up and standing. Those within the national court we know are doing their best, but we at the regional level are also doing our best, trying to collaborate and coordinate activities and make sure that we also, civil society also comes into the fray, because they are the people who push for things. For instance, in the ECOWAS court, there was no human rights violation jurisdiction. The lawyers within the region, the bar associations and civil society had to fight the authority of heads of state and government. Therefore, in 2005, they had to give the court the human rights violation jurisdiction. That has made the court what it is now, very vibrant and all. Therefore, we know that the enforcement issue is a very critical one. We keep fighting for it. We try to get them to those who are even in the dualist countries, try to what do you call it, to ratify them into their laws, so that people who get judgment before us can go into their various countries and enforce the judgment. That is being done. Then we're also trying to get them to make sure that they comply with their international obligations. So I will assure all of us that we are doing our best, and then with the support of civil society, we'll be able to do our work and support and protect the rights that are being violated by the various governments within the region. Thank you very much.
Thank you, Judge. And Mr. Bechala, your final thoughts before we move to the other two people to give their closing remarks.
Thank you, Judge Naba. Yes, I think a lot of things have been said and very interesting. I really enjoyed the webinar. I just highlight the importance of reinforcing or establishing strong partnership with regional human rights court and also judicial network. That's really important to raise awareness of judge at national level about these international standard and regional jurisprudence in order that they use it more. So really, that's really key if you want to see some change. I would say also the importance to work with National Training Institute for them to integrate models on this issue of freedom of expression. And so this is a call really on all the judicial trainers that they really use this resource to advocate at their level in their judicial training institute to adopt these things for in-service training or initial training. I think it's really an advantage for future judge or prosecutors to have these tools more clear, because they will face at one point or another probably issues related to freedom of expression or safety of journalists, etc. So, or freedom of assembly. So that, but for them, it's additional tools which we think are important. And finally, take advantage of the course that we are developing. For example, as I said, the massive online course, it's free, it's available. Please register. My colleagues put the link. There have been already over 8,000 judicial actors across the world that inscribed in this course. So it's really an important community of judicial actors which are increasing their knowledge on these issues, and so please join this community. And by signing and following this course, I think you would find it very useful. And don't hesitate to share it with your colleagues. That's really little things, but that they can bring some really positive change on the mid-long term. So that will be it.
Thank you so much. I'm going to call upon Lloyd Kuvea of the Center of Human Rights, together with Maria Badeva Bright of Africa Lee, to give us some closing remarks. Then I will let you go.
Yes, thank you very much. And I'm Lloyd Kuvea from the Center for Human Rights. I just want to appreciate, firstly, the moderator, Judge Ntaba. It's quite refreshing to see a judge who knows a lot about the subject matter on this particular issue of sedition, and other vague laws that are being used to target and silence, critics. Thank you so much. And your presentation was also quite just fascinating in terms of the subject matter. I've learned a lot, just as a lawyer, but also as an academic and civil society activist. And also want to thank Ntabi Seng for the wonderful sign language interpretation so that no one is left behind on this issue. And Justice Asante, your elucidation from the perspective of the international courts, thank you so much. Clearly, I think what I've learned from your presentation is that judges have a key role to play, just like what Judge Ntaba said, in terms of ensuring that these vague laws are struck down or that they are amended. And as you were speaking on the role of the ECOWAS court, being from Southern Africa, I was like, oh my goodness, we don't no longer have the SADC tribunal. It could have been playing a similar role for Southern Africa. And mainly, thank you so much in terms of just the resources. Certainly, I found it quite appealing, your call for us to participate in the massive online course. I think that will be very critical. And thank you so much for the resources that have been posted in the chat box, and I think we're going to utilize them. Thank you very much. But of course, I just want to, thank the Southern Africa Litigation Center and the Judicial Institute for Africa, and of course, African Lee, my colleague Maria. It's good to see you again. For really putting this together. I think this has been a beautiful webinar. And lastly, I would like to also thank the UN Special Rapporteur, Mr. Clement Vu, who has left us now, and really for encouraging civil society organizations to use the reports and the standards that his special mandate is put out. And I think it will be critical in terms of civil society activism. But just to end on a sad note, that unfortunately, in Eswatini, we have seen recently, I think last week or is it this week, the conviction of 2 members of parliament on charges of sedition and Suppression of Terrorism Act. And it's a judge of the High Court who convicted these honorable members of parliament. And I think so a lot needs to be done for Swaziland, clearly. And also Zimbabwe recently in parliament passed a law which is being termed the Patriot Bill. It's almost along the same lines as sedition and treason. So again, lawyers in Swaziland and lawyers in Zimbabwe have a lot of work to do in terms of challenging these suppressive pieces of legislation, and we hope that the judiciaries will do the rightful thing. Thank you so much. I don't want to take much time, but to also just thank, I think almost 100 people were following this discussion. So in terms of the reach, it was just amazing. Thank you very much for the resourceful and the rich discussion.
Thank you, Maria.
For having us. Thank you.
Thank you so much. Thank you so much, Judge Ntaba. I will keep my thanks very short, just to say thank you for the very able moderation and to our panelists for enlightening presentations today. I tried to share my screen. I was unable to, but I will just post in the chat. I'm here today as the director of the African Legal Information Institute, as well as a co-founder of Laws.Africa, two organizations that work on digitizing and providing the law of African countries, as well as the African Union and regional economic communities for free online access. Several times today, the panelists mentioned the need for judges as well as litigants, representatives, and counsel to consult regional materials as well as international materials. AfricanLii at africanlii.org, which is a completely free access website. You are able to search across all the African Union materials, including the African Court on Human Rights, the African Commission, the ECOWAS Court of Justice, the East African Court of Justice, and search across these regional collections, again, also in the context of national law. So I would invite those of you that are interested in doing further research and enriching your knowledge of the continental regime around the issues that were discussed today to visit AfricanLii, and all of this is available for free. Also on the AfricanLii website, as partners in this event, we have created a collection of case law guides, manuals, as well as presentations, which we hope to receive over the course of today and tomorrow. So we are publishing the materials referred to by the panelists in today's webinar. We are publishing them also on AfricanLii. If you scroll towards the bottom, there is a collection called Void for Vagueness Doctrine webinar, where you can find the case law and the presentations that were referred to in the presentations today. So with that, thank you so much, and also thank you to all the participants for showing in such big numbers, and have a good afternoon.
Thank you, and I must say, in conclusion, it has been an amazing webinar, but I think one thing we need to remind ourselves at the end of the day is that as long as the sedition laws remain on our statute book in the manner that they are in, they're not human rights focused, they do not promote and protect the rule of law, we will continue to see people coming through our court system, people coming through our prison system. And it is very much incumbent upon everyone, every player in the system, whether you are in the policing space, whether you are in the legal space, whether in the judicial, whether you're in parliament, and whether you're in the executive, to ensure that we remember that ultimately we have decided that we are going to be countries that are based on the rule of law, that promote and protect human rights. And it is fundamental that we remember that the tenet is the protection and the promotion of human rights, and that no one should be made to suffer for laws that are overly vague, or overly broad, and are ambiguous in their nature. And it is that hope that we, as institutions and as justice players, continue to work in our spaces in our various countries on that particular issue. I thank you all. And lastly, I also want to thank Livio from the ICJ, who also shared a resource, and which I think is something that is very much appreciated. And anyone else who would want to share, please get in touch with Maria, because we appreciate all the information across Africa and across the world that could be helpful. We appreciate all the information and documentation across Africa and across the world that will be used to promote and protect human rights. Good day. I did keep you a good 8 more minutes, but enjoy the rest of your day. Bye-bye.
Bye-bye.